What happens when the parliament, the ultimate voice of the people, exercises its legislative will, only for that law to be fundamentally questioned? Is there a referee powerful enough and, independent enough to challenge the highest lawmaking body in the country and declare its decision void?
That is, I think, the defining tension within India's constitutional democracy. And that power rests squarely, and I'd say absolutely, with the judiciary, which acts as the ultimate constitutional sentinel.
The sentinel.
Exactly. Today, we're undertaking a critical deep dive into the very backbone of India's constitutional governance, the concept of judicial review, and how landmark rulings have not just interpreted, but have actively shaped the legal, social, and political architecture of modern India.
Absolutely. This is a critical deep dive for anyone looking to understand the mechanics of power, the limits of legislative authority, and particularly for those of you navigating the complexities of high-stakes examinations on this very subject.
For sure.
We're drawing insights directly from foundational texts and examining how the courts continuously redefine the meaning of justice, liberty, and democracy itself. A very warm welcome to all our listeners joining this essential deep dive, especially those focusing so intensely on their preparation journey.
It's great to have you all here.
And we want to take a moment right now to give a sincere shout out to all of our existing paid members. Your support is truly invaluable.
It really is. It helps us continue bringing this comprehensive high-utility content to you.
It does. And if you find this content useful for your preparation, please consider giving us a like and sharing your valuable comments below.
And look, if you are capable, we humbly ask you to subscribe and join our paid membership on YouTube. That support allows us to keep bringing these super useful deep dives to you.
And just a quick reminder, free notes with practice previous year questions or PYQs are available on our Telegram channel.
And for our Legend YouTube members, premium notes with extra PYQs and model mains answers are waiting for you on our Discord channel, so do join there.
Okay, let's unpack this with the foundational structure. When we discuss the Indian judiciary, we're looking at something pretty distinct from many other federal systems.
Right, an integrated, unified structure.
Can you walk us through the hierarchy and maybe explain why this unified model is so important?
Sure. So the structure is a strict hierarchy, and it's really designed for consistency and finality. At the very apex, you have the Supreme Court of India.
At the top of the pyramid.
Exactly. Below that, we have the high courts in each state, and then beneath the high courts, you find this extensive network of subordinate courts. So, district courts, civil courts, and so on.
And the key word here is integrated.
That's the crucial word. This single system of courts enforces both central laws enacted by Parliament and state laws enacted by the assemblies.
Why is that so unique, especially since India is, a federal country? Doesn't federalism usually mean separate enforcement mechanisms?
It usually does, which is why India's system is often described as a sort of quasi-federal compromise. In a typical federal system, like, say, the United States, you operate a distinct double system.
Two parallel tracks.
Exactly. If a matter relates to federal law, think copyright or immigration, it goes through the federal judiciary. If it relates to state law, like local contracts or property, it goes through the state judiciary. They're parallel systems.
So in India, a single high court or district court could be ruling on a central tax law 1 minute and then a state municipal law the next.
Precisely. This structural choice ensures a unified system of fundamental law and justice across the entire country. It minimizes jurisdictional conflicts at the lower levels and, ensures that the interpretation of the Constitution and central laws remains consistent no matter which state the case comes from.
And it's important to remember, this wasn't created out of thin air, right?
Oh, not at all. It was largely inherited and then refined from the Government of India Act of 1935, which itself was looking for a strong central structure with judicial oversight.
So the conclusion is clear. Despite being constitutionally federal, India's unified judiciary is a powerful tool for national unity and legal uniformity.
And it means that the Supreme Court, sitting at the pinnacle, is the ultimate authority for interpreting and protecting that foundational text.
Which brings us directly to judicial review.
Absolutely. Because the Constitution, not Parliament, is supreme in India, the judiciary must have a mechanism to ensure that the legislative and executive branches stay within their constitutional bounds.
And that mechanism is the Doctrine of Judicial Review.
That's the one.
So how exactly do we define judicial review in the Indian context, and where does the Constitution explicitly grant this massive power?
Well, judicial review is the power of the superior courts, so the Supreme Court and the high courts, to examine the constitutionality of legislative enactments and executive orders.
From both the central and state governments.
Both. And if they find that a law or an order violates any provision of the Constitution, they can declare it illegal, unconstitutional, and therefore null and void.
And this power isn't just implied. It's anchored explicitly in specific articles.
It is. It's rooted most fundamentally in Article 13. Article 13 is the constitutional basis for this doctrine, particularly when it comes to safeguarding fundamental rights.
It's like a warning sign to the legislature.
It is. It effectively puts the legislature on notice that its power to enact law is not absolute.
And Article 13 sets up this crucial distinction based on chronology, doesn't it? Pre-Constitution laws versus post-Constitution laws.
That distinction is vital. Article 13.1 deals with pre-Constitution laws. It says that all laws in force in India right before the Constitution came into being shall be void to the extent they're inconsistent with the fundamental rights.
So it applied the new rights backwards, in a way.
It established judicial review retrospectively where applicable, but then you have Article 13.2, which is forward-looking.
And what about the laws made after 1950?
That's Article 13.2, and it's a clear prohibition. It says, the state shall not make any law which takes away or abridges the fundamental rights. Full stop.
And if they do,
any law made in contravention of this clause shall be void to the extent of the contravention. This simple provision gives the power to both the Supreme Court under Article 32 and the High Courts under Article 226 to strike down unconstitutional laws.
that brings up a fascinating term used for the court's vigilance, being the sentinel on the qui-vive.
It's a very eloquent term. It's originally French, meaning a guard on the alert. And the court has adopted this description for its function as the ultimate guardian, especially for fundamental rights.
A guard on the alert. I like that.
It signifies continuous, unwavering vigilance. The judiciary is, in theory, constantly watching, ready to intervene the moment the legislative or executive branch tries to infringe upon those core rights.
To really grasp how significant this is, we have to compare it to a system where this power doesn't exist, like the United Kingdom.
Right. The contrast here really defines the two major constitutional traditions. In the UK, the doctrine of parliamentary sovereignty is supreme.
Parliament is the final word.
It is. The British Parliament is the highest lawmaking body. And crucially, there is no single supreme written constitution against which their laws can be tested. So British courts have to apply parliamentary laws as they are written. They can't examine their constitutionality.
They can't say, this law is unfair.
They can't. India, on the other hand, adopted constitutional supremacy, which makes judicial review a non-negotiable check on legislative power. It's a foundational divergence.
But of course, this power is only meaningful if the judiciary is truly independent.
That's the bedrock.
If judges are beholden to the political executive for their jobs, they can't possibly act as a sentinel on the qui-vive. So how is that independence practically secured?
Well, the Constitution provides several guarantees. Security of tenure, high salaries, non-discussion of their conduct in the legislature, the complex impeachment process.
But the appointment process itself is where the real tension lies.
It is. And the key safeguard is the mode of appointment itself, which insulates judges from pure executive discretion.
So how does the current system curtail the executive?
Constitutionally, the president appoints Supreme Court judges, but this has to be done in consultation with the Chief Justice of India and other judges. This has effectively led to what we call the Collegium system.
Which was established through court judgments, not the original text.
Correct. And this system significantly curtails the absolute discretion of the executive branch. It ensures that judicial expertise and seniority, rather than political preference, dominate appointments.
And we have a definitive, very recent example where the Supreme Court basically went to war to protect this very mechanism. I'm talking about the Fourth Judge's case and the NJAC.
Ah, yes. The Fourth Judge's case in 2015, that is a powerful historical moment. Parliament, trying to reform the, let's say, opaque Collegium, passed the 99th Constitutional Amendment Act and the National Judicial Appointments Commission Act.
The NJAC.
Yes. The NJAC proposed replacing the Collegium with a commission that included the Chief Justice, two senior-most Supreme Court judges, the Union Law Minister.
And two eminent persons.
Right. Nominated by a committee, including the Prime Minister and the Leader of the Opposition.
The idea was to bring in transparency and accountability, things critics say the Collegium lacks. So why did the Supreme Court strike down an amendment passed almost unanimously by Parliament?
The court's reasoning was profound. It determined that the inclusion of the union law minister and the mechanism for selecting the eminent persons introduced an executive and legislative presence into the selection process,
which they saw as a threat.
a fundamental threat to judicial independence. The court explicitly argued that judicial independence is a foundational element of the basic structure of the Constitution. Therefore, Parliament, even with its amending power, could not destroy it.
So the verdict reinforced the Collegium, but more importantly, it was this massive exercise of judicial review, not just striking down a law, but protecting its own operational autonomy from a constitutional change.
Exactly. This verdict showcased judicial review at its absolute peak. The judiciary used its constitutional power to defend a basic feature, its own independence, against a perceived threat from the other two branches.
Okay, let's move from the fundamentals to what might be the most advanced and consequential judicial doctrine in India, the basic structure doctrine.
The game changer.
This doctrine effectively defines the upper limit of Parliament's constitutional power. So let's start with its revolutionary origin.
It all comes from the monumental Kesavananda Bharati versus State of Kerala case in 1973. This case came up during a period of really intense confrontation between the judiciary and the Indira Gandhi government.
They were passing a lot of amendments back then.
Rapidly, pushing through socioeconomic policies, often curtailing fundamental rights. So the central question before the largest bench ever, 13 judges, was whether Parliament's power to amend the Constitution under Article 368 was truly unlimited.
And the verdict, delivered by a razor-thin 7-6 majority, was history-making.
It really was. The Supreme Court held that, yes, Parliament does possess the power to amend any part of the Constitution, including the fundamental rights. But, and this is the critical caveat, Parliament cannot, through its amending power, expand that power to repeal or abrogate the Constitution, nor can it destroy its essential features or its basic structure.
So it's like saying you can renovate the house, but you can't knock down the foundation walls.
That's a perfect analogy, and this was a direct response to Parliament's attempts to establish its own absolute authority.
How did this doctrine immediately nullify Parliament's overreach? I'm thinking of the 42nd Amendment.
It immediately checked it. The 42nd Amendment of 1976 tried to give unlimited amending power to Parliament and explicitly said that amendments couldn't be challenged in any court.
It tried to make Parliament supreme.
It did. But post-emergency in the Minerva Mills case in 1980, the Supreme Court used the basic structure doctrine to strike down those clauses of the 42nd Amendment. They effectively said that judicial review itself is a basic feature of the Constitution.
So you can't amend the Constitution to get rid of judicial review.
Precisely.
So judicial review is protected. Judicial independence is protected. What else have the courts defined as being part of this basic structure?
Oh, the list has expanded over time, providing these crucial guardrails for the whole system. Key components include the supremacy of the Constitution,
Of course.
the Republican and Democratic form of government, the secular character of the Constitution, separation of powers, the federal character.
The unity and integrity of the nation.
Exactly. And critically, the balance between fundamental rights in Part 3 and the directive principles in Part 4.
Let's focus on that balance established in Minerva Mills. Why is the balance between rights and policy goals considered so basic?
Because the court recognized that both Part 3 and Part 4 are the constitutional conscience. Part 3 gives you these irreducible individual freedoms. Part 4 sets the socioeconomic goals for the state.
One is the individual, the other is the collective.
In a sense, yes. If Parliament were allowed to make directive principles totally superior to fundamental rights, which the 42nd Amendment tried to do, it could just erase individual liberties in the name of progress.
And the court said no.
The court ruled that such an action would destroy the harmony and balance that defines the identity of the Constitution itself. The state must strive for welfare goals while respecting fundamental liberties.
Okay, so the basic structure doctrine deals with amending the Constitution. But what about ordinary laws? The courts need tools for that too. Let's start with the Doctrine of Severability.
The Doctrine of Severability is a tool of, let's call it, constitutional prudence. It's also rooted in Article 13. It asks a very pragmatic question.
Which is?
If a part of a law violates a fundamental right, do we have to scrap the whole thing?
And the answer is usually no, as long as you can separate the bad part.
Correct. The principle says if only a specific section of a law is inconsistent, then only that inconsistent portion is declared void, not the entire statute.
But there's a condition.
There is. The valid part must be able to stand on its own and still serve the original legislative intent. If the invalid part is so integral that removing it gets the whole purpose of the law, then the whole law has to fall.
It makes sense. It saves everyone from having to restart the entire lawmaking process for one small flaw. Can you give us an early example of this?
A classic case is A.K. Gopalan versus State of Madras from 1950, which we'll discuss more later. In this case, dealing with the Preventive Detention Act, the Supreme Court found Section 14 to be unconstitutional.
It violated Article 22.
It did. But applying the Doctrine of Severability, the court struck down only Section 14. The rest of the Preventive Detention Act was declared valid and operational.
So they surgically removed the problem without killing the patient.
A very good way to put it. Now let's pivot to the doctrine of pith and substance. This is fundamentally about maintaining order in the federal distribution of powers.
The seventh schedule stuff, union list, state list.
Exactly. This doctrine is crucial for the smooth functioning of federalism because, inevitably, laws passed by the union or the states will accidentally touch upon a subject allocated to the other list.
So the court needs a way to figure out what the law is really about, not just its side effects.
Precisely. The doctrine of pith and substance says that when a law is challenged for encroachment, the court has to examine the true nature and essential character, the pith and substance of the act.
So if the substance of the law falls within the power of the legislature that made it,
then the law is held valid, even if it incidentally trenches upon or touches a subject in another list.
Let's make this practical. Say a state government passes a law regulating the storage of some industrial chemical. Public health is on the state list, but industries is on the union list.
The court would look at the dominant purpose. If the law's core objective is the safety and public health of its citizens, a state subject, then the law is upheld, even if it incidentally affects the national industry.
A concrete example from the sources is the Industrial Disputes Act applying to municipalities.
Yes, exactly. The validity of that parliamentary law was challenged because it applied to municipalities, and local government is a state subject.
Right.
But the court upheld the law. It said its true pith and substance was industrial dispute, which is on the concurrent list, so Parliament was perfectly competent to legislate on it. The incidental effect on local government was ignored.
These doctrines show the judiciary as this crucial arbiter, an interpreter. But sometimes the judiciary steps out of that neutral role and becomes much more proactive.
Judicial activism.
Exactly.
Judicial activism is a philosophy where judges consciously move beyond a strict interpretation of the text. They allow their own views on public policy, social justice, and evolving societal needs to guide their decisions.
The goal is to mold the law.
To mold the law to suit the changing social and economic scenario. It's an assertion that the judicial branch has a primary duty to ensure constitutional ideals, liberty, equality, justice are actually realized.
Even if that means stepping into areas that are usually for the executive or legislature.
That's the tension.
We're talking about unelected judges, potentially writing policy. How do the courts justify this democratic deficit?
The justification usually rests on two pillars. First, the failure of the other two branches to act on constitutional mandates, especially for the voiceless.
And second,
the expansive definition of fundamental rights, particularly Article 21. When a human right is being systematically violated and the state machinery isn't responding, the courts argue they must intervene to fulfill their role as the sentinel.
but there is a line, right, a boundary that the courts themselves have tried to define.
Absolutely. The court has issued a strong warning. Judicial activism must not become judicial adventurism.
Adventurism.
Yes, the judiciary must not unduly take over the administrative functions of the executive. Adjudication, the court insists, must operate within historically validated restraints.
And the main vehicle for this activism is public interest litigation, or PIL. How did PIL tear down the traditional barriers to justice?
PIL revolutionized access to justice by relaxing the traditional rule of locus standi.
Which means
Traditionally, only the aggrieved party, the person whose rights were directly violated, could approach the court. This excluded millions of people who were poor, illiterate, or just too disadvantaged.
So PIL allowed a third party to go to court on their behalf.
Precisely. Under the liberalized PIL regime, any public-spirited citizen, a social action group, an NGO, they can approach the Supreme Court or a high court for the enforcement of the rights of those who can't do it themselves.
Justice becomes a public concern, not just a private one.
That's the heart of it. And this opened the floodgates for the judiciary to address these deep, systemic governance failures.
What specific areas have seen the most impact from documented PIL cases?
The impact has been transformational, focusing heavily on human rights. We've seen petitions from jails about prisoner harassment, demands for a speedy trial.
Which is now seen as part of Article 21.
Exactly. PILs against police malpractice, deaths in custody. And crucially, PIL has addressed systemic atrocities on women dowry deaths, bride burning, rape, forcing the executive to implement stricter guidelines. PIL became the voice for the silent majority.
Let's turn now to Article 21. No person shall be deprived of his life or personal liberty, except according to procedure established by law. Such a short sentence, but it's become the most fertile ground for rights expansion.
It really has. But its original interpretation was startlingly restrictive.
You're talking about the 1950 A.K. Gopalan case.
That's the one. The court adopted a strictly textualist approach. It focused very narrowly on that phrase, procedure established by law.
And what did the court say that phrase meant back in 1950?
It meant literally state-made law. The court held that if the legislature passed a law with a procedure for depriving someone of liberty, and the executive followed that procedure, then the courts could not question the fairness or reasonableness of the law itself.
So protection was only against arbitrary executive action, not arbitrary legislative action.
Correct. If the procedure established by the legislature was itself arbitrary, the courts were powerless to intervene under Article 21.
That meant the legislature could pass nearly any oppressive law as long as they followed the rules to pass it. That's so different from the American idea of due process of law.
Absolutely. The American due process includes substantive due process. Is the law itself fair and reasonable? The Gopalan judgment explicitly rejected that, leaving personal liberty very vulnerable for almost 3 decades.
The big shift then came in the post-emergency era. The 1978 Maneka Gandhi versus Union of India case.
The Maneka Gandhi case is arguably the most important judgment on individual rights. It explicitly overruled the restrictive approach of Gopalan.
What did it do?
The court adopted a radically wider interpretation of Article 21. It created a 3-part test. The procedure established by law must not only be enacted law, but it must be fair, just, and reasonable.
So by adding fairness and reason, the court effectively inserted the ethos of substantive due process into the Indian Constitution.
That is the essential insight. The Supreme Court effectively mandated a new constitutional standard. If a law deprives a person of liberty, the court can now scrutinize the law itself. It has to satisfy a triple test.
Okay, what's that?
It must be a valid procedure, it must be enacted by a competent legislature, and crucially, it must pass the test of Articles 14, equality, and 19, freedoms. This meant any procedure that's arbitrary, unfair, or oppressive is no procedure at all in the eyes of the Constitution.
Wow, that one verdict transformed Article 21 completely.
It became the most expansive source of fundamental rights in the entire document.
So once that door was opened in 1978, the Supreme Court began connecting the right to life to the right to live with dignity. It wasn't just about physical survival anymore.
Not at all.
What are some of the critical rights that are now considered integral to Article 21?
Well, the expansion is really a testament to judicial activism filling in governance gaps. The right to live with human dignity is the philosophical umbrella. Under that, the court has included so much. The right to livelihood and shelter, the right to health, the right to a decent environment.
Which includes pollution-free water and air.
Yes, through a series of landmark PILs. Also the right to speedy trial and legal aid. The right to privacy, which was conclusively affirmed in the Puttaswamy judgment.
And the right to free education.
Yes. The court held that the right to education up to 14 years of age is integral to Article 21, and that ruling eventually led to the 86th Amendment and the creation of Article 21A.
This expansion really shows the court actively bridging the gap between constitutional promises and social reality. Let's look at the ultimate deprivation of life: capital punishment. How did the courts balance the death penalty with this new, expanded Article 21?
This balancing act happened in the landmark Bakhan Singh versus State of Punjab case in 1980. The court found that capital punishment is constitutional, as long as it's awarded according to a fair, just, and reasonable procedure.
But they had to harmonize it with the new scope of Article 21.
They did, and to do that, the court mandated that the death penalty must be treated as the exception rather than the rule.
And that gave rise to the iconic rarest of rare doctrine.
Exactly. The court held that the penalty must be confined only to the rarest of rare cases. The procedure required courts to consider the circumstances of the crime, the criminal, and to record special reasons for choosing death over life imprisonment.
The standard being that the alternative.
The alternative option of life imprisonment must be unquestionably foreclosed before the ultimate sentence can be given. It imposes significant judicial restraint.
Okay, moving from life and liberty to equality. Articles 15 and 16, which deal with non-discrimination and equality of opportunity. The judiciary played a role here right from the very start.
It did. The initial challenge came almost immediately with the Champakam Dorarajan case. The Supreme Court struck down reservation quotas in Madras, arguing they violated the fundamental right to equality under Article 15.
Which was a massive political problem for the government.
It's a huge setback, and it led directly to the very first constitutional amendment.
Right. To overcome that verdict, Parliament enacted the First Amendment in 1951, inserting Clause 4 into Article 15.
Precisely. This clause specifically empowered the state to make special provisions for the advancement of any socially and educationally backward classes, or for the SCs and STs. It laid the foundation for the whole reservation framework.
But the most consequential case defining the limits of reservation was the Mandel case in the early 90s.
The Indrasani versus Union of India case in 1992. It's the definitive ruling on the scope of Articles 15.4 and 16.4. The Supreme Court upheld the constitutional validity of the 27% reservation for other backward classes, or OBCs.
But the court also introduced some key caveats, right, to keep reservations within constitutional bounds.
Two major caveats. First, it mandated the exclusion of the advanced sections among the OBCs, what we call the creamy layer, from the benefits.
To make sure it reached the truly needy.
Exactly. Second, the court established the crucial principle that the total quantum of reservations must not exceed 50%, except in certain extraordinary circumstances.
And the Indrasani judgment also looked at the idea of reservation for economically weaker sections, outside the SC/ST OBC categories.
It did, and at that time, the court rejected it. It rejected a proposal for an additional 10% reservation, stating that economic criteria alone could not be the sole basis for reservation under the existing articles.
Which Parliament later addressed through another constitutional amendment.
Yes. In 2019, Parliament enacted the 103rd Amendment Act, which introduced a new category for reservation based purely on economic criteria, economically weaker sections, or EWSs.
And this added new clauses to Articles 15 and 16.
It did, allowing the state to provide up to 10% reservation for EWSs in education and public employment, explicitly bypassing the social and educational backwardness criteria for this specific quota. It shows that constant interplay between judicial interpretations and legislative responses.
This deep analysis is great, but now let's link these judicial checks and balances directly to real-world governance challenges, the kind of linkages crucial for Maine's themes. Let's start with the huge challenge of land reforms.
Land reforms in the 1950s, abolishing zemindari, imposing land ceilings. This was the first major clash between constitutional property rights in Part 3 and the directive principles in Part 4.
And the judiciary initially sided with property rights.
It did, repeatedly striking down state land reform laws. So the legislature had to use constitutional surgery in a way to save these socioeconomic policies from judicial challenge.
And that's where Articles 31A, 31B, and 31C come in.
Exactly. The need for these exceptions is a direct result of judicial review. The First Amendment introduced 31A and 31B. Article 31A saves laws related to agrarian reform from being challenged on the grounds that they violate Articles 14 and 19.
And what was the immediate critical mechanism that provided that blanket protection?
That was Article 31B, which created the Ninth Schedule. Any law placed in the Ninth Schedule is insulated from judicial review, even if it violates fundamental rights.
A constitutional lockbox.
It was a legislative attempt to permanently shield important policy choices, like land reform laws, from judicial scrutiny.
Okay, let's pivot to another major governance theme. Tribal administration under Article 244.
Article 244 and its associated 5th and 6th schedules detail the distinct systems for administering scheduled and tribal areas. And this is an area that frequently intersects with judicial scrutiny, especially concerning the rights of indigenous populations.
The sources link the non-implementation of 5th Schedule provisions directly to internal security challenges, like left-wing extremism. If the constitutional administration is flawed, the judiciary often has to step in.
That's right. The lack of proper governance, especially over land and resources in scheduled areas, often leads to rights violations, pushing the judiciary into activism. The court frequently has to intervene to ensure the spirit of the PISA Act is implemented.
Which gives tribal communities control over their resources.
Exactly, aligning governance with their fundamental right to culture and dignity.
Can you just quickly highlight the distinct purpose of the 5th and 6th schedules? They are often confused.
The distinction is critical. The 5th schedule covers scheduled areas in most states. It relies on the governor and tribal advisory councils, so it's a sort of governance control mechanism within the state's executive structure.
And the 6th.
The 6th schedule, however, covers those 4 specific northeastern states: Assam, Meghalaya, Tripura, and Mizoram. Its distinct purpose is to preserve their democratic traditions and cultural autonomy through the creation of autonomous district councils,
Which have lawmaking powers.
almost like miniature legislatures. It reflects the historical context of self-rule in those areas.
Finally, let's look at how the judiciary acts as a checker on the legislature's internal workings. The Anti-Defection Law, or 10th Schedule, is a perfect example.
The 10th schedule was introduced to curb political defection. The decision on disqualification rests with the presiding officer, the Speaker of the Lok Sabha, or the chairman of the Rajya Sabha.
It was meant to be an internal process.
Swift and internal. But once again, the judiciary stepped in to ensure this powerful position wasn't misused.
The Quijado-Holohan case.
That's it, from 1992. The Supreme Court ruled that the decision of the chairman or the speaker regarding disqualification is subject to judicial review.
So while the speaker makes a first call, the court can examine if that decision was arbitrary or malified.
Exactly. It's a vital check and balance. The court asserted that no authority in a constitutional democracy can have unchecked, non-justiciable power.
And the Supreme Court has also been at the forefront of broader electoral reforms, aiming to clean up public life.
Indeed. A major intervention was the 2013 ruling on the immediate disqualification of convicted MPs and MLAs. Previously, Section 8(4) of the Representation of the People Act gave them a 3-month period to appeal.
A loophole.
A huge one, which allowed convicted persons to stay in office. The court's action was radical. It struck down that provision of a central statute.
So it declared Section 8(4) unconstitutional.
It did, stating that conviction for a serious crime means immediate disqualification. No grace period. It was a clear demonstration of the judiciary's willingness to invalidate legislative provisions that undermine democratic ideals. And so we've reached the conclusion of this extensive deep dive into the Sentinel on the qui-vive. I think the central takeaway has to be the dynamism of the Indian Constitution. The judiciary is not merely an interpreter, it is an active, powerful constitutional conscience.
That's a great way to put it.
We've seen how its evolving doctrines, from the basic structure to PIL and the transformation of fundamental rights, ensure that the procedural aspects of law always meet the substantive tests of justice, fairness, and reason.
This nuanced understanding, connecting specific articles to landmark judgments and contemporary governance issues, is so essential for transitioning from just rote learning to true mastery of the subject. We hope this deep dive gave you profound clarity on the fundamental tools the judiciary uses to fulfill its unique and really non-negotiable role as the protector of the Constitution and the rights of the people. Now for our final provocative thought for you, the learner. Given the immense power of judicial review, especially the rarest of rare doctrine, and the continuous expansion of Article 21 into policy domains like environment and health, where do you draw the line?
A tough question.
Should judicial discretion extend further into areas traditionally belonging to the executive and legislature? Or is greater judicial restraint needed to preserve the spirit of the separation of powers? This tension between activism and restraint is what defines the future of governance in India.
Don't forget to like this video and share your valuable comments about this deep dive. Your engagement helps us tremendously in understanding what content serves you best.
And remember, free notes with practice PYQs are available on our Telegram channel, and premium notes with extra PYQs and model mains answers for our Legend members are waiting on Discord.
We are so immensely grateful to all our existing members for enabling this detailed work. If you are capable, please subscribe and join our paid membership on YouTube to support the creation of future deep dives of this quality.
Thank you for joining us on the Deep Dive.